The late DA, Richard Brown's legacy is one of a hard-charging, tough-on-crime prosecutor. Queens is now the most punitive borough. The district attorney's office sends more offenders to jail for misdemeanor charges than any other New York City DA. Would you continue this stance or change it? If so, how?
No, I will not continue the stance. I think that we're in a situation where we have to look at crime and we have to look at the criminal justice system in a larger picture, and looking at not only the charging of the case and the proving of the case, but also the circumstances of the person accused of the crime, what's going on in their life, what's driving the misconduct, and the impact on the community. Because if we're just looking at the crime and the charges, then we're missing the big picture, which is what's driving crime. If I'm serious about public safety, I have to make sure that individuals who are addicted to drugs, have mental illness, receive the services they need so that they don't recidivate, do additional crime and become, continued revolving door patrons of the criminal justice system. I think that's the wrong idea, and that's what we've been doing for the last 28 years.
What do you want to see happen? What kinds of things would you like to see change so that you wouldn't continue that stance?
Well, the first thing is we're going to decline to prosecute low-level offenses, which includes possession of a gravity knife, jumping a train stile in the dark, in the park after dark. Low-level offenses that have nothing to do with public safety. Then we're going to take the remaining of nonviolent offenses and we're going to try to divert whenever possible, especially our kids. We're about treating kids like kids and not saddling a young person with a criminal conviction for the rest of their life. We're about, like I said, addressing the issues of the circumstances of the person accused of a crime. Do they have a mental illness? Do they have a drug addiction? Are they a veteran who's self-medicating with alcohol and drugs, who are suffering PTSD? These are the issues we have to identify. We have to provide services and divert those from the criminal justice system. With the cases that we have to prosecute, which are the violent felonies and the violent crimes, we have to be sure that we're doing the right thing. We're respecting people's rights. We're making sure that we're giving over discovery as early and as often as possible. We're making sure we're not dragging cases out for years on end where individuals are sitting in incarceration, not having been convicted of a crime, and simply waiting for their day in court. That has to stop on day one, and that will stop on day one around
So is it the age of the defendant that's going to matter in terms of how you treat them?
Absolutely. With the raise the age law, we're looking at deferring a lot of the cases involving 16-year-olds. In October, it will be now 17-year-olds. And I think that the position of the district attorney's office is to defer those cases to family court. This is why science has proven that an individual's mind doesn't fully develop until the age of 25. So why are we treating these young kids who are making mistakes in their lives because their minds are underdeveloped or because they haven't experienced life thoroughly? Why are we treating them like adults? Why are we punishing them? Why are we not redirecting them into family court where they get the services not only for the for the child, for the young person, but also for the family and also for the community that they come from? That's more sense than just to straddle a young person with a criminal conviction that's going to deny him school, is going to deny him an opportunity for employment, it's going to deny him even such a thing as a license to be a barber. And I think that's where we have to look at things when we're talking about kids, is we have to treat kids like kids and make sure that we give them the second chance in life that they need to be productive members of our society.
So following that, what's your position on the so-called broken windows offenses, public urination, turnstile jumping, for example?
Those offenses will not be prosecuted under my administration. This is why we have to focus on violent crime. I have limited resources as the district attorney. We have over 300 attorneys, same amount of investigators, and I want to focus on breaking up human trafficking rings, breaking up drug trafficking rings, gun runners, trying to take the gangs in Queens and break them up and do long-term investigations that's going to reduce crime, because that is what the Queens residents want. They want public safety. They want their families and the community safe, and that's what they're looking for the district attorney to do. Prosecuting these low-level quality of life crimes is not a public safety issue. Many of these crimes could be resolved with administrative process through issuing of summonses and paying tickets, and I think that's the appropriate approach to those offenses, not the criminal justice system, who really should be focused on reducing crime and preventing recidivism.
So the use of recreational marijuana is still against the law in New York State. Are there any marijuana prosecutions that you would undertake?
Yes, absolutely. Large-scale sale of marijuana, which includes, the distribution and sale of large-scale quantities of marijuana. This is why, because whenever you look, and this is where experience trumps political rhetoric. You have individuals who have taken political positions in the race that have no experience as prosecutors. As a prosecutor, I know that when you have a large-scale enterprise distributing marijuana on a grand scale, you have also firearms. You often have individuals who are caught up in violent crime. You have, overlapping with human trafficking. You have overlapping with other drugs. So you really have to know where the crime is and where you have to focus your resources. And the large-scale distribution, even of marijuana, is an opportunity for the district attorney to do long-term investigations and wrap up other type of violent crime in this type of investigation.
What about the sale of marijuana near a school or the sale to minors?
That's also something we have to prosecute and address. What we are not going to focus on is the simple possession, the low-level possession of marijuana, the low-level, basically the low-level possession of marijuana.
Well, what's low level? Is it like an ounce? What do you call it? A cigarette?
It's all the misdemeanor charges. I could tell you that. It's all the misdemeanor charges and some of the low-level nonviolent charges, which is up to certain grams and grains. However, because we know that it's moving towards legalization, to prosecute and convict individuals for something we know will be actually legal in a matter of months is not consistent with justice, because we will be saddling them with convictions knowing that the law is going to change in a matter of a year or so.
The new bail statute does not allow someone to be held pre-trial for misdemeanor assault, even though this is one of the most frequently used charges, the initial charge in a domestic violence case. Do you support this change in the law, and how do you think it will affect your domestic violence prosecutions if you were the DA?
I support the law, but I even support it going even further. I don't want anyone held in incarceration only because they cannot afford to buy their freedom. I don't want anyone at Rikers Island simply because they're too bored.
Even if it's misdemeanor assault?
Even if it's misdemeanor assault, because I think that when you're treating people differently. The individual who has $500 in the bank account will be released. The individual who does not will not be released. So it's a two-tier system, and you cannot continue a two-tier system where people with money are treated differently.
But what if it's a domestic violence case?
If it's a domestic violence case, we have to treat those cases very seriously. But
so you would treat it differently? Would misdemeanor assault be treated differently in a domestic violence case?
No. What we will do differently in a domestic violence setting is provide the services we need to protect the victims. We have to do, and there are services out there that will allow for us to be more proactive in protecting the victims, separating them from their abusers, and making sure domestic violence survivors have the services and the protection they need to feel comfortable cooperating with law enforcement and pursuing the charges that are pending in court.
So should sex workers be prosecuted? What about people who own buildings where this is happening?
I don't believe, I will not prosecute sex workers as district attorney. What I will do is prosecute the pimps and the human traffickers. Those individuals who engage in the business of sex work for the benefit of personal gain and based on the exploitation of others. So these are the individuals that bring in people from abroad under false pretenses, sometimes under coercion, and then exploit them for the purpose of just benefiting themselves.
The people who own buildings where this is going on?
You have to look at that on a case-by-case basis. Are they knowingly operating? Are they the human trafficking ring that's actually exploiting individuals and pushing this type of illegal activity, into the community? If so, then we need to prosecute them, and that's why you have to have experience doing the job, because you have to know how to differentiate the individual who's is just a business owner, a building owner, and that individual who actually is engaged in the activity, providing shelter and safe haven for a criminal activity that we have to break apart.
So since Richard Brown was such a tough prosecutor, should there be a review of all sentences of people over 30, for example, and would you recommend reductions, and if so, for what?
I would recommend reductions in certain cases where the charge is now illegal conduct, such as certain marijuana
Well, do you want to
possession.
review some of the cases people have been in jail for a long time?
Absolutely, I would like to review those cases because some of those cases are based on evidence that we know is to be junk science. We know that certain areas of forensic science have been deemed to be unreliable. And if the conviction of that individual was based on unreliable scientific evidence, it's justice demands that we review the case and see if we should commute the sentence or reduce the sentence. In addition, we have the individuals who were arrested and prosecuted and convicted as youth, at 16, 17, 18 years old. Now we know, because science tells us, that the mind isn't developed until the age of 25. Then we should look back at those individuals and see what the circumstances of their life was at the time of the crime, to see if we should exercise our discretion to commute and reduce those sentences, because now we know what the real effects of children are in the criminal justice system. And to just allow them to dwell in the criminal justice system endlessly, it doesn't promote public safety.
So basically what you're saying is that our view of what the criminal justice system should be has changed dramatically since Richard Brown took office.
I believe when Richard Brown took over office, I was growing up in East New York, Brooklyn, and I saw violent crime in the streets. So I was seeing the war on crimes playing out in the streets. And I was also being subject to racial profiling. So I was being stopped by the police for no other reason than because of the color of my skin. So I saw what the circumstances were when Richard Brown came in. And under those circumstances, I felt he needed to take a hard stance on law and order in order to maintain, in order to bring down crime stats. And I understand that. But we're in a different world right now, where crime is down, and that we have to look at making the system fairer and more equal for everyone, not criminalizing our poor, not criminalizing those addicted to drugs, not criminalizing the mentally ill. Those are the things that we have to look at now, because the old way of law and order, incarcerate everyone that comes into the system, has just led this country to be the most incarcerated country in the world without due cause, I think. And I think we need to look, just like we looked at the Rockefeller drug laws, to look back and say, wait a minute, we made a mistake. We need to rethink the way we approach this issue.
Next question. Discovery laws have recently changed.
Yes.
What's your position on the requirement that witnesses to crimes have their identities provided to defendants before trial? And what steps would you take to protect witnesses from pretrial intimidation?
And again, this is where experience trumps political rhetoric. I've been doing this for 18 years. When I started as a prosecutor in the Brooklyn District Attorney's Office over 18 years ago, we had open file discovery in every type of case. And they've been doing it for 20 years in Brooklyn without risk to the victims or the eyewitnesses. So for someone to say there's going to be a danger to witnesses and eyewitnesses, it's non-existent. It really is non-existent, because there are mechanisms in the law that allow us to protect individuals' identity when we feel they're threatened, when we feel that there is a real threat of intimidation, harm, or even death against them by others in the community. So we can get a protective order. We can get a judge to authorize us not to release that information. Right now, what the law has changed is it took away the discretion of the district attorney to withhold information, because in a widespread, statewide way, district attorneys were holding on to information at the very last minute and dumping it right before trial, and that created an injustice. That created an unfair system where individuals were being convicted based on evidence that they received just before the last juror was sworn.
But you sound like you also are willing to challenge the law when necessary.
Absolutely. Absolutely, I'm willing to challenge the law. For instance, I'm willing to challenge the District Attorneys Association of New York. They're opposing the prosecutorial conduct commission, and I think that's a critical commission that we have to look at prosecutors, prosecutorial misconduct, and to make sure we have a fair system for all.
So, would you actively investigate charges of tenant harassment?
Absolutely.
Why?
I think that's a real issue. Not only tenant harassment, I also think deed theft is a real issue in Queens, because we have big developers coming into Astoria, Long Island City, and other areas of Queens, pushing individuals out because they want to raise rents and they want to increase market value of their property. And it's changing the culture, it's changing the dynamic of each of our communities, and once it's changed, it's forever gone. And I think we have to protect our citizens, our traditions, and our communities that have been there for so many years.
So how would you handle requests from ICE?
I will pen a policy in my office that will make sure that anyone at the district attorney's office does not release information to ICE. There's only two
Never.
individuals, never, and anyone releasing information to ICE will be subject to investigation and possible disciplinary action. The only people that have right to information from the district attorney's office are the victim and the attorney of the accused. That's it. And any other outside agencies are not, because it's confidential information and it's information that we shouldn't be releasing. I think that any cooperation with ICE, makes us less safe, because individuals living in the shadows now don't cooperate with law enforcement. The immigrants that fear ICE will not come forward when they are victims of crime, will not come forward when they're eyewitnesses of crime, will not cooperate with law enforcement. And under those circumstances, crime is not going to go down. It's going to go in the wrong direction. It's going to go up, because this is an entire segment of our population that is living in the shadows, and we have to encourage them to come out of the shadows and cooperate with law enforcement to make sure we're all safe.
So, do you think that Rikers Island should be closed?
I don't agree with any new prisons in any of the 5 boroughs, and I think that Rikers Islands can be closed because we can decarcerate the population to the extent that we allow it to be closed.
Those seem to be mutually exclusive positions. You're against new prisons, but
That's
you
right.
want to close Rikers. So where are you going to put people?
We have existing stock of detention facilities throughout all 5 boroughs that we can use, and we can close Rikers Island by decarcerating the population, and we do it in 5 ways. The 5 ways I spoke to you before: declining to prosecute low-level offenses, make sure we divert nonviolent offenders away from the criminal justice system. We give over discovery so we can expedite the cases in the system. We play fair so we're not dragging cases out for years on end, and we make sure that we respect individuals' rights so that we're not asking them to waive their rights to be free pending trial.
But surely there must be some people who you'd want to incarcerate, people who
Absolutely.
are involved in murders or
Absolutely.
big drug cases or
Absolutely.
assaults that are particularly heinous.
Absolutely.
So where are you going to put these people? If you close Rikers, and that's about 9,000-10,000 people,
Right.
There's got to be some portion of those people that you still want to incarcerate. Where do they go?
The existing detention facilities in the 5 boroughs. Right now, there's only 4
But are
boroughs.
they up to snuff? I mean, the knock on Rikers
Right.
is that they're old, archaic jails.
Right.
And do you want to go from dungeon to dungeon?
No, I think we could use the money, the billions of dollars that we were going to pour into building 4 superstructures that hold about 3 times as many people. Instead of using it to actually build these structures, we can renovate and build up the existing stock, so it's safer, it's more humane, and it's better system of detention for pretrial confinement. And we have to remember, pretrial confinement is not punishment. We have to get out of the mindset of saying, well, somebody needs to pay, therefore they have to go to jail. Pretrial detention is only to ensure the person's return for a future date.
And you're saying they haven't been proved guilty, so why should they pay a penalty?
If you have a system when you're innocent until proven guilty, then we can't say at the same time, but we're going to punish you even before we convict you. Either you're innocent until proven guilty or you're not. And there are certain circumstances that we do have to detain individuals because they're a threat. They're a demonstrated threat to the public. How do we know they're a demonstrated threat? Because they've done it in the past. Because the nature of and the gravity of the offense, they're being charged with. Because the overwhelming evidence that shows that they're a violent individual and they have violent tendencies. Those individuals we do have to detain, because public safety requires it. And when public safety requires it, detention is going to be necessary. And I will promote remand in certain circumstances where I know that there's a demonstrated risk to families and communities in Queens.
So would you try to get them sent upstate to upstate jail so the New York City wouldn't have to keep them?
No, they would be in the facilities that we have. We have multiple facilities in each county. We have a facility in Queens, we have a facility in Manhattan, we have a facility in Staten Island.
So you think the Queens House of Detention is up to snuff?
We can renovate it to make it up to snuff. And instead of making billions, investing billions of dollars, changing the entire nature and character of Kew Gardens, we can renovate what we have already and making sure that it's up to snuff to do the job.